Well, for starters, Jeff, I'm a trial lawyer, primarily on the business side and civil matters, not criminal matters, and have been for over 40 years. In addition to that, practicing law and representing people in court as well as before mediators and arbitrators and regulators. I also have served as a mediator and an arbitrator. And the alternative dispute resolution piece is something that I've taught for several years over at Boston University Law School, and have lectured and written about that and trial practice and procedure. So that's pretty much my background and how it fits into perhaps the topic that we're going to expand on today.
Good. And so what's our next section, our next chapter on mediation?
Well, we talked about what mediation was and how it differed from arbitration and court proceedings, I think, the last time. And I think perhaps what we might want to talk about is the timing of a mediation, and from the client's point of view, as well as perhaps lawyers. And we could then get into the choice of a mediator and what you ought to be looking at for that, and then how to maybe maximize your opportunities once you're into the mediation.
Well, hopefully we'll get through it all today, and if we don't, we know where you're going to be in chapter 3.
You know how to get me, yes.
Yes, we do. So, do you want to start with the client-lawyer part?
Yeah, insofar as the mediation is concerned, once you've made the decision that you want to try mediation in order to dispose of the matter, the timing of it is something that also needs to be thought about clearly. Obviously, if you can mediate a dispute at the outset of the dispute, that has a lot of benefits, obvious benefits. You're disposing of the matter early on. You're saving yourself a lot of time, energy, aggravation, and cost. And to the extent that you can do it early on in the process, whether it's before litigation actually erupts, or whether it's even after litigation has been filed, that's a good thing. The bad thing about an early mediation and a disposition is you may be shrifting yourself, whether you're on the plaintiff's side or the defendant's side, because you really don't have all the facts at your disposal in evaluating the claim, whether you're looking for to be a plaintiff or defending a matter.
So it's not you're not defined as much in your argument, correct?
Well, it's correct, but most importantly, in terms of the ultimate disposition, you may be, when I say short-selling yourself. For instance, if out of the box you might think that you have a claim worth X number of dollars, or that as a defendant that you can resolve this matter for only X by resolving it very quickly, and before you know all the facts as a lawyer and also as a client. You may end up in a situation where ultimately, had you been more patient in the process and mediated it later on down the road after you've gone through the discovery period, or at least part of the discovery period, you may have ended up with a better result.